CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS
Talk
Talks.
to me.
CLS
Talk to
Talks.
me.
Real information.
Talk to me.
Real education.
Talk to me. Talk to me. They don't talk to me. They look like that morning. They don't talk to me. They back that morning. They don't talk to me. They back that morning. They don't talk to me. They back that morning. They don't talk to me. They back.
Welcome back to the latest in our series on the art of war. Des Carty's with me. Welcome as always, Des.
Thanks very much, Lionel. It's a pleasure to be here. Right, an army may march great distances without distress if it marches through country where the enemy is not. Okay, well, again, just to codify or link this back to what we're doing, I think this relates to you're doing your own independent research when you're outside of the battlefield per se, and to stay away from the battlefield for as long as possible. As we discussed earlier about one of the cases you were involved with, you stayed away from the court practically 2 years before you actually went into the battlefield or had an assessment, and even then you only went in to assess the battlefield.
Plus, I wasn't sitting on my arse doing nothing for those 2 years. I was marching.
Yeah. So the great distance here is time, isn't it? That's really what Sun Tzu is saying to us, right? In other words, take your time independent of doing battle with them. Take the time out to research, to understand what it is they're doing. Send in your spies, perhaps give them the odd prod every once in a while, as you've done with a letter or whatever it might be. So to me, great distance is time, I think, anyway. And distance closes as well as time does. So the nearer you come to the 2 years or 3 years, they always want to decide cases very quickly. But the quicker it's decided, the greater a chance you have of losing.
Yeah.
I think.
Yeah.
In the early days, certainly.
I totally agree.
Yeah.
The next one, you can be sure in succeeding in your attacks if you only attack places which are undefended.
Yeah.
And that's common sense. And again, we spoke about the Gardaí under cross-examination. That's the equivalent of going in and attacking the undefended, because the Gardaí just don't have a clue. They don't know the law. They don't know how to conduct themselves under cross-examination, and they become so flustered. They don't know how to perceivably defend themselves.
Well, it's that, and I do agree and concur with what you just said, but there's a wider thing with attacking places that are undefended. Right, don't forget, we shouldn't forget, obviously, is that when you're dealing with, say, a bank, you also have a solicitor, possibly a barrister as well. You certainly have a judge involved in basically making a determination, possibly. But outside of that as well, you've other, if you like, groups, societies, companies, whatever, that are attached to the barrister, the solicitor, the judge, the banks. There's a whole plethora of state institutions as well that support and work with these different characters or personas in the court. So you can attack, for example, and we'll just give one example for the moment because I know we're tight on time today, and we will elaborate upon this. For one example, going back a couple of years ago, we were involved with a case whereby a solicitor was acting the maggot. So we decided at the time to attack the solicitor where he least expected it, to basically keep him in his place, because he was misbehaving himself at the time. Now, they all do, obviously. So what we did was we found out who his insurers were, okay? And he'd done some nefarious things in the court in terms of affidavits and all the rest of it. There was a lot of dubious goings on. So we wrote directly to his insurance company. And solicitors are mandated to have professional indemnity insurance.
Yeah.
So if you raise an issue or infer to a solicitor that you could potentially sue him for malpractice or whatever it happens to be, a solicitor has a duty of care to report back to their insurance company that there is a potential case pending. Okay. So we wrote to the insurance company and asked the insurance company if the solicitor in question had actually written to them to inform the insurance company that there was a potential case pending, that he was potentially going to be sued over malpractice or what he's done with the courts or affidavits. And that was fine. They wrote back and said, well, we can't disclose information. Now, the solicitor went mental.
I can imagine so.
Yeah.
That hits him in the pocket.
Yes. Now, the solicitor didn't state that the insurance company were considering withdrawing insurance. But it was a small practice. He eventually withdrew from the case.
Okay, well, that speaks volumes.
Yeah. Because we hit him where it counts. Now, he didn't, this is where, but the unexpected. Yeah, if you want to take out a key player, at the time it was a solicitor, but we knew it was only a small firm. The bigger firms obviously have more clout,
Sure.
so on and so forth, but it was a small firm. So basically, the man that was involved in the case, he didn't want to do this, but we said, look, consider it. And in the end, he did do it. And the solicitor...
Why wouldn't you want to do it?
It's psychology again,
Yeah,
isn't it? It's
because-
conditioning.
If someone's shooting at you,
Yeah.
and the only thing to do to defend yourself is to shoot back, why would you not shoot back if you couldn't run away from those bullets?
Yeah. Well, again, this is conditioning. This is what we talked about again, deception. You've been deceived into thinking, well, those lads are just doing a job.
Yeah.
They're not just doing a job. They're destroying people's lives.
Plus, they do make it personal. If you look at the vehemence with which those that attack you actually do so,
Yeah.
it becomes a personal thing. The ego gets involved on their side, and it's not just people doing a job, it's people loving the job that they're doing.
Oh, well, again, this ties back to that term that Sun Tzu has about the method of attack. It's direct and indirect. So we'd be inclined to show people or explain to people methods of indirect attack, which may be able to help you. And again, it's your decision, obviously, at the end of the day, whether or not you want to use these methods. But again, it's a form of deception. You're not attacking in the way the enemy expects you to attack. And
Sure.
we made the reference earlier to the Vietnam War. The American soldiers were not prepared for that type of warfare. All they were prepared for was one army over here, another army over there, and fire bullets at each other.
Yeah.
They weren't prepared for jungle fighting or landmines or tunnels or all the other stuff the Vietnamese employed during the war. Okay.
Next up, military tactics are like water. For water in its natural course runs away from high places and hastens downwards. So in war, the way is to avoid what is strong and strike at what is weak.
Well, if you want to play into the system, you basically will lose. It's that simple.
Yeah.
If you play the game, and they are a very strong opponent. And the other thing that in most cases won't help you is if you play the game in the context of employing a solicitor or barrister, they are not going to go against the strong themselves. Because let's just say a barrister stroke solicitor decided to go in there and they won a case, a big case in the court. That then sets a precedence for other cases to be won potentially. But the barrister or the solicitor will never work again. And they know this. You know, they can't beat the system. So they themselves, the barristers or solicitors, will not go against the strong. And they see the system, the state, the banks, the other solicitors, the other barristers and the judges as being the strong. They will not fight the strong. So why would you do that yourself?
Yeah. Let your plans be dark and impenetrable as night, and when you move, fall like a thunderbolt.
Okay.
That one really resonates with me, I must say. It's a great one. It's about diversionary tactics and potentially sending red herrings. The Trojan horse is another good one that I like, because it is amazing. You can through letters and through correspondence and notices and demands and all kinds of things, you can lead the opposition up a particular path.
Yeah.
And they can think that they're being very clever, and because there is an arrogance always, they can think they're being very clever and they see what your game is. But if you actually plan then on your day in court in going in a completely different direction, even if they have been in some way assiduous about the path that you've led them on in preparing for it, well, they don't know what's happening when that thunderbolt does fall. And again, I've seen that happen once or twice firsthand. It's amazing how if you disarm the enemy, they have nowhere to go. They can't run, they're backed into a corner, and they've nothing to fight you with.
Yeah, I mean, we have some brilliant examples which we'll get into in terms of more detail later on, in terms of going back through these things. But a recent example of something I've had was we were working with this man, and it was in relation to basically a civil stroke criminal matter. And the man didn't understand, because we had a strategy. Now, to be honest with you, we didn't let him know the exact strategy because we feared he might let the cat out of the bag.
Okay.
So he went in and he employed the strategy. And the strategy was actually for the court to give an order. And he couldn't understand, like, well, why would I want an order? And ultimately, we want the order because the order in and of itself, the way it would be put together. Now, the order has not yet been perfected, right? If the order had been issued, now there was a judgment, a decree, if you like, but the order yet has not been actually issued. But we want the order. They made a determination in the court on the day about whatever it was, and now then we wrote to the court demanding that the court produce an order because we wanted out of the issue to be transferred out of the circuit court into the High Court, and we can do that if there's an order.
Yeah.
We created a mini battle about something that was insignificant rather than the main case itself, and we lost that issue. But off the back of that, we want the order. So now, when we get the order, if we get the order, it'll be transferred into the High Court on appeal.
Okay.
So it's out of the circuit court.
Whole new
So
battleground.
the danger is less then, because in the circuit court it was a criminal matter,
Okay.
but now once we get it transferred into the High Court, it becomes a civil matter.
Why is that, or how is that?
Well, it's the issue we're talking about. Now, the issue that was raised. Now, I know we're getting into a little bit of detail
Yeah.
here, but it's a very interesting issue, and we'll discuss it again at another time because we'll have more progress in the case and all the rest of it. So the issue that was raised, that we wanted to raise, and the man couldn't understand why we'd raise an issue like this. We raised a motion for contempt
Right.
by the prosecutor. We averred or alleged that the prosecutor was in contempt of the court. Now, the court could not resist but dealing with this issue because it didn't want the case to continue in the context that there was a suggestion that the prosecutor was actually in contempt of the court. They had to deal with it. So the judge made the determination. Now, we knew the determination was going to be that the prosecutor were not in contempt of court because they can't have the case continuing
Yeah.
otherwise. So we knew the decision was going to be basically they determined that the prosecutor was not in contempt. Now, the man couldn't understand why we'd even want such a thing or even put it in because he said that's not about what the case is about. We said we know it's about something else. So the judge made the determination that there was no contempt, okay, where there clearly was, and we said fine. So now we want the order. Now they don't realise as soon as we get that order, it's into the High Court. So there's no chance of the man being imprisoned in terms of the circuit court criminal case against him. It's now been transferred as a civil matter that has to be decided in the High Court.
That is sneaky. I love it.
Now, we didn't tell the man the detail of this. We suggested that that's what might happen.
Yeah.
But we couldn't because he had to stand there in court and aver or make this allegation. Now, it was done on paper. It wasn't just done verbally as well. It was done on paper. So now we're in a position whereby either we get the order or the motion before the court of contempt still stands.
Okay.
Does that make sense?
Yeah. Yeah, I gotcha. That's a beautiful tactic.
Now, that's like we talked here about let your plans be dark and impenetrable as night, and when you move, fall like a thunderbolt. Now, we've moved from, and they didn't see it coming. Now, unless they did, but I can't imagine they seen that coming.
I don't think so.
Because they were like, they were basically so aggressive towards this issue of them being in contempt. It was like a bombshell to them. You were averring or alleging that the prosecution were in contempt of an order of the court. Now, they were, but there wasn't a need to make such a big deal out of it. No, we did. This is what we do with people, and people work with us on, is we look at the small minutiae
Yeah.
and think, how can we expand that up into something that is nuclear?
Yeah.
Okay? So that has helped, obviously, the whole case, because now it's not in this jurisdiction of the circuit court, it's in the High Court.
Yeah. Different ball game, different
ballgame,
battleground.
Different battleground.
Yeah.
And it's never going to leave the High Court.
Oh, it's beautiful. I love it. It's also a very timely place, I think, to leave things for today. We will, of course, be back next week with more of our expanded treatise.
Can we add in the last thing in terms of the
Sure, why not? Let's do it.
I think it's the most appropriate, one of the most appropriate things, which is ponder and deliberate before you make a move.
It's so important, isn't
Yeah.
it? It's so important, and you can look at that at a macro level or a micro level. Even if you're in court, in the heat of battle, and things aren't going the way that you expect them to go and you're a bit flustered, take your time, because we wouldn't want to rush to judgment, would we?
Absolutely not.
So let the judge or the registrar or whoever it is know that you wouldn't be comfortable with a rush to judgment. Take your time,
Yeah.
think about what you're doing, and if that means getting the hell out of there, you find a way to do that.
Okay.
Great stuff. Thanks again for joining me. It's always a pleasure.
You know, welcome, Lionel, and we'll talk again soon.
They don't talk to me, they look like blue that morning.
The CLS Talks.